Yesterday we started a new topic. It's on vicarious liability. We discussed the reasons, the principles behind this. When someone is held liable for no fault of, their own, and those principles were, the first one was two basic principles, and another third one is, social policy considerations. The first two were qui facet per alium facet per se, he who does an act through another does it himself. The second one was respondeat superior, because the servant would be responding to the superior's order, that will be the master, and hence master is to be held liable. And then there was one more reason why the same is done. It's because usually the masters, or the principals, they have much more resources, or much more capacity to distribute the losses that they suffer. So keeping that in mind, responsibility is, the master as well as, or principal are held liable for wrongs done by their servants or agents. So here there has to be a special connection, though. A special kind of relationship has to be there. It is that special relationship which is the reason behind why one is held liable for the wrongs of another. So you have master-servant relationship. Well, the servant is under the control, under the direction of the master. So it's a special kind of relationship. So if a servant does any wrongful act, not in servant's personal capacity, in the sense that servant is not the slave of the master. Servant has his or her own life. A wrongful act done by the servant in their own life, in their own capacity, personal capacity, will not make the master liable. But if a servant does anything that is wrongful, a wrongful act, but in the course of employment, then the master is liable. So the wrongful act has to be done during the course of employment. So in such case, if you remember, it's a case of joint and several liability. So both the master as well as the servant would be liable. So Lord Chelmsford had said that it has been long established by law that a master is liable to the third persons for any injury or damage done through the negligence or unskillfulness of a servant acting in his master's employ. The reason of this is that every act which is done by servant in the course of his duty is regarded as done by his master's order. So whatever the servant does in the course of employment is considered to have been done under the order of the master. And consequently, it is the same as if it were master's own act. So the master had delegated the act. So it will be held as if the master had, themselves done that act. So that's the rationale behind this, idea of vicarious liability. Now the question arises as to who is a master and who is a servant. So from whatever we have discussed, it is that the master is the person who is in control and the servant is the one whose actions are controlled. So the master is, the person who is legally entitled to give certain orders, to the servant, and the servant would be then bound to obey them. So that's essentially the relationship. The person who orders is the master, and the person who's ordered, who's bound to obey is the servant. So master essentially means a person who employs the servant. A person who employs another person, subject to certain terms and conditions, to work under his lawful orders and supervision. So that's essentially the relation. So master is a person who employs another. The person who is employed is the servant, okay, and the service would be subject to certain terms and conditions, okay, and then the servant would be subject to the lawful orders and supervision of the master. So yes, how do we know that the master servant relationship actually exists? Okay, so the relation of master and the servant would exist where the employer cannot only direct what work the servant is to do, okay, but also control the manner of doing such work. So this is a very important point that you need to remember. It's not merely about directing someone to do something, but the master also has control of how the work is to be done, the manner of doing the work, okay, because if the second element is lacking, then it's a different kind of relationship, okay. However, at the same time, we should be cautious here that quite often servants do things which are not in accordance with the directions given by the master. But would that mean that the master is not liable for such acts of the servant? Well, not really. We will discuss that in greater detail, but for now, for the sake of beginning or understanding of the relationship, we need to keep in mind that when the master-servant relationship exists, the master does not merely direct what is to be done, but also controls the manner in which the said work is to be done. So in such case, if while doing the act, okay, which has been directed and authorized by the master, okay, if the servant commits any wrong, any tort, then the master shall be held liable, as well as the servant, okay. So now the question arises, who is the servant? I think we have already discussed that. It is already clear from this definition. So if the master is the person who directs, who orders, okay, who controls, servant is the person who is controlled, who is directed. So that's the definition of a servant, okay. So a servant is a person who is employed by another to do work under the directions and control of the master, okay, as simple as that. So here, remember, the servant, when we talk about servant, it's not, you are not to equate it with how the relationship of master and slave used to be there. It's not that, okay. The servant voluntarily agrees, okay, into the contract of employment, okay. So the terms and conditions of employment are there, okay, which based on which the servant would voluntarily enter into agreement, okay. So a servant is one who voluntarily agrees. It could be for for some wages or other payment, okay, or that may not be there, to subject himself during the period of service to the lawful orders and directions of another in respect of work done by him, okay. So it's making very specific here that the servant is subject to only lawful orders and directions, okay. But then if the servant does something which is unlawful, would the master be liable, okay? Well, that's a question that needs to be addressed, that we will do in the course of our discussion. Well, at this stage, now that it is quite clear what's the relationship between a master and a servant, there is another kind of relationship, okay, that might be there and resembles closely to that of master and servant. Well, it is so close that even judges find it difficult to distinguish between one and the other. So the second kind of relationship in which the master is not held, usually, okay, not held liable, although there are exceptions, we'll discuss, liable, is the case of a independent contractor. So are you guys with me till now?
Yes, sir.
Huh? Okay.
Yes, sir.
So the distinction is to be drawn between a servant and an independent contractor, okay. So the legal relationship between the master servant would be different from the relationship that would be. Yes.
Sir, actually, before we go into the independent contract, sir, I have a doubt in servant.
Yes, tell me.
Sir, is the servant served more than one master at one point of time? Like in a bank, sir, a banker working under the so many masters. So is that possible?
Yeah, why not? I mean, unless the term and condition of the employment says that while you are employed under me, you cannot be employed under anyone else. Okay. So, I mean, that happens. Okay. It's usually not allowed because you have the freedom to enter into, contract of service with anyone. But then certain restrictions can definitely be employed. Okay. So, for example, while I'm employed, the regulation of this university says that while I'm in the service of this university, I cannot be in the service of someone else. Okay. So, yeah, such restrictions can also be imposed. Okay. So, yeah, but then that does not mean that one cannot be under the service of two different persons. So, for example, someone who's, your gardener, okay, could also be a gardener for someone else, okay. Um so that's very much possible. I mean, it's not unthinkable that such a situation, arises. Quite often people, earn their living by being employed under many different employers. So that's possible. Why is it not? But then who is to
Okay.
be held liable? Who is to be held liable? I mean, in such case, it would depend on, okay, the tort has been committed while under being, the service of which servant, okay, in the course of employment of which servant. That will determine which, master is to be held liable. Are we clear?
Yes, yes, sir. Thank you.
Okay. Okay, so it's very simple. See, lot taught is very simple, very logical. Only sometimes it becomes little difficult. But then you see, even in those situations, judges do not come to conclusion arbitrarily. They have to use logical reasoning. So yes, so now we are going to distinguish the relationship between master and servant, and then of that of a independent contractor. Okay. So there is a difference in relationship. Okay. The difference usually, normally it is that, the master has some kind of control over the way that servant, does something. Whereas the person, you know, would have no control over how something is done when it comes to independent contractor. Okay. So that control element is traditionally understood to be the differentiating factor. Okay. But then we have gone way beyond and past this idea of control. Okay. But for now, just understand this that there is a difference. Okay. So what is the difference? It is said that a servant is engaged, okay, under a contract of services, whereas an independent contractor is engaged under a contract for services. So you see the difference: servant, contract of services, okay, independent contractor, contract for services. So what is the difference? So a servant is under your employment, okay. Servant is your employee, okay, under an employment. Whereas in case of independent contractor, they are in a contractual relationship with you to do something very specific. Some specific service is to be provided to you. Okay, so it's a different kind of relationship. Do you understand from this basic combination of words? Your servant is engaged, okay, under a contract of services. So there is a service, okay, and for which the servant is employed, okay, and that contract is with respect to the services which will be provided generally. Whereas in case of independent contractor, it is a specific service which is to be provided by the independent contractor. So that's a different kind of contract. Okay, so one is case of employment, the other one is a little different from that. So I'm struggling to tell you exactly how it is different, but I think the basic is conveyed to you. Other discussions will make it clear. So is the basic clear to you?
Yes, sir.
Huh?
Yes, sir.
Sir,
Okay.
I just have one doubt. So,
Uh-huh.
like the whole gist of whatever we have done with regards to the difference, the whatever difference we have done till now, it basically says that the independent contractor maybe has a little more autonomy to his work as compared to a servant, or am I
Yes,
getting it wrong?
yes, very correct. So the element of control we said, whereas in the case of contract of services, that is in the case of servant, the master has a lot of control over how the servant, does a particular act. Okay. Now, for example, if you employ, so if you remember the case of, mm, recently we discussed about strict and absolute liability. Okay, so one of the exceptions that we discussed, okay, was what? If the act was done by, okay, an independent contractor. Okay, do you remember? But in case of, what do you call it? In case of strict liability, that is not considered as one of the exceptions. Okay, so we'll come back to this. Okay, we'll come back to this. I think I'll get you guys confused if I bring strict liability. So in case of strict liability, even the independent contractor, so we had referred to this back then. Okay, Rylands versus Fletcher is the case that we had discussed, if you remember. Okay, so the act of digging there was done by an independent contractor. However, the party was nonetheless held, responsible. But I think I'm just getting you confused by bringing that. For now, just keep this in mind that, as one of you have rightly pointed out, in case of independent contractor, the person who employs the independent contractor has much less control compared to that of someone who's his servant. Okay, so obviously the autonomy is much higher. So for example, if you're employing an engineer to do something very specific for you, so the engineer has much higher discretion in that situation as to how that particular act is to be done. Okay, particular result is to be achieved. Okay, whereas an engineer could also be employed, okay, by you. Okay, but then it's a different kind of relationship. Okay, as you could see. So what happens is that in case of independent contractor, okay, you tell the independent contractor to achieve a particular result. Okay, but you do not tell that person to do that in a certain way. That person will use just a second that person will use his or her own expertise to achieve that result. Okay, so that's a case of independent contractor. Yes, now tell me what's the
So I was just asking that we can't dictate the mode of operation as such, right?
Yeah, I mean, it depends to a lot extent upon the expertise of that particular person.
Yeah.
Another difference would be, okay, another factor would be that, you employ a servant generally, okay, not for specific purposes. Okay, whereas in case of independent contractor, you employ that person, if at all you should call it employment. Okay, you give that person a specific task to be completed, okay, based on their expertise. So that specificity generally it is another helping factor for us to differentiate between a contract of services, that is the case of servant, from contract for services, that will be the case of a independent contractor. Okay, so is that clear?
Sir?
Yes.
Sir, one doubt. Like, suppose in a law firm said to a lawyer to his employee, like, go and do the merger of these two companies. So, sir, in this, the lawyer employs his own knowledge, his own method of style for that merger. So, can we say that employer is in relationship of master servant or independent contractor?
See, the thing is, based on this limited fact, a conclusion cannot be arrived at. Okay, but then let me tell you, it's difficult for me to imagine that one lawyer will be entrusted in any such thing. Okay, it's a huge job. And apart from that, see, in what capacity has that person been entrusted? Okay, if for example you are talking about a law firm, so it seems that the lawyer is one of the employees. So from the limited facts that you have, information that you have given me, it seems to be a case of contract of services rather than contract for services. Do you see? This is, you have not, appointed a lawyer for a specific purpose. It's a lawyer who's already employed with the firm. Okay, so then specific task is given.
Okay, so thanks a lot, sir.
But anyway, limited facts will not be helpful. As you will see, we will look at some cases. Even the judges do struggle in making this distinction. Okay, so And then when you talk about firm, it seems to be a case of partnership firm. Then depends. Okay, so many other factors are there. So anyway, we'll have to look into the terms and condition of employment. Okay, how has this person been employed? Okay, and what are the responsibilities? Okay, so many factors have to be looked into to find out that whether it's a case of independent contractor. It's clear in your case. It clearly seems to be a case of contract of services. So anyway, so a servant is an agent, okay, who is subject to the control and supervision of the employer, okay, how the particular work is to be done, the manner in which a particular work is to be done, okay. Whereas in case of independent contractor, okay, such degree of control is not there. But then, this is not the end of the discussion, because sometimes, one might retain certain, control, okay, but what about those situations? Okay, so many things have to be looked at apart from the fact that, okay, control is essential. And in case of servants, okay, quite often servants do things which are not authorized by the employer. Okay, what about those situations? We'll look into all those. Okay, so the simple criteria would be one who undertakes to produce a given specific result, okay, but so that in the actual execution of work he is not under the order or control of the person for whom he does it, and may use his own discretion in things not specified beforehand. So you do not lay it out in detail as to how the thing is to be done. You leave it up to the expertise of that particular person to achieve a particular result. If it is of that sort, then it seems to be the case of independent contractor. Okay, now let's look at some cases, okay, and that might help us a little bit. Okay, so with respect to the first element that we identified, okay, the first element is who exercises control and to what extent is the control is exercised. Okay, so that is traditionally what has been used to differentiate between the case of servant and that of a independent contractor. Well, this used to be the case in earlier societies when such relationships used to be very simple. Okay, you employ someone to do something very specific for you, or you employ someone to be in your permanent employment. Based on those limited relationships, you could easily distinguish between what is a case of servant and what is not a case of a servant. Okay, but in today's time, due to complications in complications in how one could be under the service of another, we need to go beyond the control test. Okay, and the difficulty with respect to distinguishing these two has been rightly discussed in many different cases. One very important case is Dharangadhara Chemical Works Limited versus State of Saurashtra. I'll just type it here, just a second. Okay. So this is a case in which the judges, discussed about how difficult it is. Okay, you have to look at specific situation, fact situations, terms and conditions of employment, service, whatever, to identify. So it has been said in this particular case that the existence of the right, okay, in the employer, not merely to direct what work was to be done, but also to control the manner in which it was to be done. The nature or extent of such control varying in different industries. Okay, that this control cannot be uniformly defined. Okay, in some industries it could be very specific, in others it is not. You employ someone to be a driver of your lorry, then you do not tell the driver to you probably give them a route that is to be used, but then they also get to exercise their own discretion. Okay, if there is a heavy traffic, they might take a detour. Okay, but would you say that the driver has done something which is outside the course of employment, which seems to be not directed by the master, and hence it's not a case of master-servant relationship? You wouldn't come to that conclusion immediately. So that is what is being said. Okay, the nature or extent of such control varying in different industries and being by its nature incapable of being precisely defined, because in some industries they might need higher degree of control, in others not so much. Okay, so it said the correct approach therefore was to consider whether, having regard to the nature of the work, there was due control and supervision of the employer. So you cannot define what is due control and supervision now for all different cases that might come before you. So you have to look at the specific factual details, and without that you cannot. So it's not possible for me to tell you specifically how these two things are different. But if specific fact situations are brought before us, then it will be much more possible for us to distinguish. So it was further said that the existence of the right in the employer, not merely to direct what work was to be done, but also control the manner in which it was to be done. Okay, that is very important. Okay, that now, as I told you, the control will vary from one industry to another. In some, much higher discretion is given, in others much less discretion is given. So you have to keep all those standards into in your mind to decide. So yeah, so that essentially tells us the difficulties with using this particular test, okay, known as the control test. So you also have to look at something called the nature of employment. What is the nature of employment? So that is very important for you. So why is that? Because in different kinds of employment, the standard of control would also vary. So with respect to this, I'm sharing this case with you. Just click on this link and you will find it. It's the case by the name Ready Mixed Concrete versus Ministers of Pensions. Okay, so this is very important. Okay, so it is an accepted view that people who have a contract of service, okay, that is a contract of employment, okay, are employees. As I told you at the very beginning, in one case, it is the case of someone being under the employment. Okay, so for example, I am an employee at this university. I am not an independent contractor. Okay, but there are others who may have contract for services. Okay, and that nature of employment would be again different. They are asked to achieve a particular purpose. Okay, now don't use it to make this distinction. Okay, so for example, I might be employed here in a permanent capacity, but there are those who might be here in a contractual capacity. But in either of these cases, the example would be what do you call it, contract of services. Okay, not for services. Okay. So yeah, in this case, look at this particular case by the name Ready Mixed Concrete versus Ministers of Pensions. The facts are: a driver contracted with a mixed concrete company for delivery of concrete. Okay, the contract declared him an independent contractor. The contract says that the driver is an independent contractor and set out wages and expenses. The driver was to purchase his own vehicle, yet with a requirement that the vehicle be painted in company colors. And he was to drive the vehicle himself, but under compliance with certain company's rules, including, for example, the manner of vehicle repairs and payments. So the question that arose was as to whether the driver was an employed person under a contract of services with the company for the purpose of whatever. Okay, so it was held, firstly, the court held that whether a contract creates a master-servant relationship between an employer and employee is determined on the basis of contractual rights and duties, and that the nomenclature used in the contract is irrelevant. So even if it says it's the case of independent contractor, but the terms and conditions of service might point otherwise. Okay, so it says further Thus, the fact that the contract termed the driver to be an independent contractor is not material. Secondly, the court held that employment under a contract of services. So these are the three important points that you must remember. So the court held that the employment under the contract of services exists when a person agrees to perform a service for a company. Okay. So a person agrees to perform a service for a company in exchange for a remuneration. And as you see in this particular case, there are wages and payments. Okay, so remuneration was given. And then a person agrees expressly or impliedly, as is the case with contracts, okay, to subject himself to the control of the company to a sufficient degree to render the company, the master, including control over task performance, means and time. And thirdly, contractual provisions are consistent with ordinary contracts of service. On the facts, the court held that the driver had sufficient freedom in performance of his contractual obligations, as he was free to decide the vehicle, his own labor, fuel, and other requirements in performance of the task. In lieu of these freedoms, he was an independent contractor and not an employee of the company. So, as you see from this specific thing, okay, you have to look at the degree to which this person who has been employed has freedom to decide things for themselves. Okay, so that degree of control ultimately helps you in identifying whether it's a case of independent contractor or it is not a case of independent contractor. So that's definitely important, but to what extent the control exists will depend on the nature of the industry in which it has been employed. Okay, and one more thing to keep in mind is that the agreement in itself is what is written on the face of the agreement, okay, in itself is not sufficient. You have to look beyond what is written there to identify the degree of freedom which is exercised by the person who has been employed. If the freedom is beyond certain threshold, then it has to be a case of independent contractor. But if it is the control is much higher, then it will be a case of servant. So yes, the nature of employment definitely helps us. So how do you identify the nature of employment? You have to look into the terms and conditions of the service, okay, of the service of employment. That will help you. Apart from that, another important case, okay, that you need to look at is by the name Jordan Harrison Limited versus McDonald's Evans. Okay, I'll just share the link to the case with you. Just a second. So if you click on it, you will get a link to the said case. Okay. So another important factor would be whether the act is the purpose for which the said person has been employed, task, okay, whether that is integral part of the business or not. If it is, then there are higher likelihood of it being a case of a servant than not. Okay, so look at the facts of this particular case. Okay, in this particular case, an engineer wrote a book that used knowledge that he acquired. Okay, so we are talking about engineers again. So an engineer wrote a book that used knowledge that he acquired while he was working for a firm in different capacities. Okay, so this particular provision provides that if the author of a work was under a contract of service, then the first owner of the copyright shall be the person by whom the author was employed. Okay, so that is very important here. Okay, whether it is a case of contract of service or contract for service, because that will determine who is the owner of the copyright. So the issue was the question arose as to whether the person was considered to be an employee under the contract of services for the purpose of allotting copyright. Who gets it? Okay, the person who has employed or the person who has produced it. So it was held, okay, by the court they essentially distinguished between contract of service from contract for services. Okay, the court applied the traditional control test as we discussed earlier concerning whether the employer has the right to control the way in which a person does the work. The court further stipulated that a person is considered an employee under the contract of service when the work is integrated in that business. Okay, so that integral part of the business or not, that will determine. So, sorry, anything? Okay, so the court looked into whether it was integral part of the business or not. Okay, so the court further stipulated that the person is considered an employee under the contract of service. Okay, when the work is integrated in that of the business and considered an integral part of the business, whereas an independent contractor for services is merely an accessory to the business. Okay, thus not an employee. So based on the facts of the case, the court concluded that the engineer's contract was mixed between the two at different times. So it held that the engineer was the author of the work, but that specific material that he acquired whilst he was employee fell within the uh, Copyright Act 1911 and should be excluded from the publication. So this whole thing essentially tells us, okay, so you have to look at specific facts of the case for you to identify very clearly as to whether it's a case of contract for services or it is a contract of services. The simple distinction which has been drawn here is that the task which has been assigned to the said person, okay, will help us in determining whether it's a case of a contract of service or contract for service. Okay, if the task which has been assigned is very much integral part of the business, this is what they do in that business, okay, regularly, generally, this is what they do, okay, then you would consider it as a task which is integral part of the business. Okay, and if someone has done that, okay, then it will be considered that someone is the servant of the this employer here. Whereas if the task is not something that is integral to the business, okay, then it will be assumed, okay, it's not conclusive, again it's not conclusive, okay, then it will basically raise an assumption that, well, this is the said person was not in a contract of service but in contract for service, because it's a task which is not integral part of the business. So maybe that person has been employed to achieve a particular result, okay, which is not part of the business, and hence that person is considered as a independent contractor. So I hope this is clear, but then as you have seen, this is not the end of the entire discussion. Okay, this is not the end of it. In every specific fact situation, the judges have to go into the details to find out what has been done. Okay, and from that they have to identify, they have to apply all these different tests and then find out the nature of the employment, and from that they can say that it is a case of servant or it is a case of independent contractor. So there's one more test that we need to look at. You have to identify the economic reality. Okay, so that's very important for us. Okay, so I have just shared a link with you. It's another very important case, okay, by the name City of Montreal versus Montreal Locomotive Works Limited. So you have to look at what is the underlying, okay, economic reality. Okay, so in this particular case, okay, this particular, whatever the board, okay, was asked whether a corporation, okay, the party that was deciding whether a corporation was the occupant of armaments factory so as to be liable to pay occupation tax, okay, and whether it was carrying on a business in the factory so as to be liable to pay a business tax. Okay, so see, this two differentiates the kind of legal relationship here. So the answer to both questions depended on whether the corporation was acting as government's agent in the former case, in the manufacture of armaments, or as an independent contractor. So all the funds necessary for the enterprise were provided by the government, which bore all financial risks. The corporation was subject to the government's control in making the armaments, okay, and received a fee for each unit of the production. So it's giving you details of what was the economic relation between the one who has been employed and the government that has employed. So that can definitely then help you, okay. So it was held that the corporation was not liable to pay the taxes. So it was said. So again, they laid down a very elaborate test to find out whether it's a case of employment or merely a case of independent contractor. So Lord Wright said, in earlier cases, a single test such as the presence of or absence of control was often relied on to determine whether the case was one of master and servant, mostly in order to decide issues of tortious liability on the part of the master or the superior. In the more complex conditions of modern society and modern industry, more complicated tests have to be applied. Okay, so mere control is not sufficient. It has been suggested that a fourfold test would in some cases be more appropriate. A complex involving, first you look at control, that's very important. Then you look at ownership of tools, okay, who owns it, okay. If it is owned by the person who has employed, then you can say that it's a case of servant. But if it is owned by the person who has been employed, then you would say that, well, it's a case of independent contractor. Then chance of profit, okay, who makes the profit, okay, from what is done. If the chance of profit is higher for the person who has employed, then obviously you will say that, well, it's the case of the master, it's the case of the master who has employed servant. But if otherwise, then we will come to different conclusion. And risk of loss, okay. So all these factors would essentially determine. So it has been further said that control in itself is not always conclusive. Thus the master of a chartered vessel is generally the employee of the ship owner, though the charterer can direct the employment of the vessel. So you see, control is not sufficient for us. Again, the law often limits the employer's right to interfere with the employee's conduct, as also do trade union regulations. So it does not mean that control is not helpful, because how much control that the master exercises is regulated by other laws. Further, it was said, in many cases, the question can only be settled by examining the whole of the various elements which constitute the relationship between the parties. In this way, it is in some cases possible to decide the issue by raising the crucial question, whose business is it? Or in other words, by asking whether the party is carrying on the business in the sense of carrying it on for himself or in his own behalf and not merely for a superior. So, so from this, again, I am quite sure you will not be able to come to a conclusion as to, from these limited cases, how any other future case that will come before you, as to whether that will be a case of contract of employment or contract for service or contract of service. Okay, so you have to look at, as has been rightly pointed out in this case, to many different factors and not merely control. Control is not enough. Okay, you have to look at many other factors, as has been rightly pointed out in this case. Okay, so you have to look at, for example, it has been pointed out who has the control, who has the ownership of tools, who has the chance of making profit. Okay, so as you know, in case of servants, well, it is always the master who has the higher chances of making profit, and so would be the case with that of loss. Okay, so all those factors will definitely help you in identifying whether it's a case of servant or it's a case of independent contractor. So are you guys with me till now?
Yes, sir.
Huh? Yes.
Sir, can you
Yes.
please tell the difference between a ship owner and the charterer?
Sorry.
Means you explained it through that example, so I searched about the meaning of master of chartered vessel.
Okay,
Can you
so in
elaborate?
this particular case you are referring to.
Yes, sir. Yes, sir.
Okay, so owner is essentially the person who actually owns the vehicle, what do you call it, the vessel here. Okay, and charterer would, I'm not quite sure about what's the relationship there, but even I need to look into it. I need not confuse you, but you know that the relationship with that of the charterer would be different than with that of the owner who would be directly owning the ship. Okay, so but with respect to how the difference is, I mean the relationship is different, I need to look at what is the relationship that stands with respect to that of the charter. So I will do my research and then come back to you rather than confusing you guys with my guesses. Okay, so give me some time, I'll look into the difference in the relationship, only then will I be able to tell you concretely. Okay, but for now just keep this in mind, apart from going into all other details. It is this, that control in itself is not sufficient. You have to look at various other factors. So the economic reality is very important. Okay, in the last case that we just discussed. Okay, why is that very important? Because the economic reality helps you in identifying what kind of relationship it is. Okay, so as you know that master will have higher likelihood of making profit from a business. Okay, a master will have higher likelihood of also losing from the same business. Okay, and a master would also have ownership of the tools which are used. Okay, so for example in the other case that we discussed, the vehicle was owned by the person who who was employed. Okay, in the case of ready mix concrete. Okay, so all these factors definitely help us in differentiating, but with respect to this specific case, I need to go into looking at what kind of specific relationship that is, to be able to tell you guys very clearly. So yeah, so excuse me for now, I will go back to it and then I'll come back and answer. So the next question is that, well, the employer is liable only when the work is, okay, the wrongful act by, I mean, the tort that has been committed by the servant is, when is it? When is the master liable?
When the tort is committed in the course of the employment.
Yes, exactly. So when the tort is committed in the course of employment, so you know that a servant is not your slave. Okay, so servant has their own lives. Okay, so and they do things in their own personal capacity. Okay, so for wrongs done by them in their own personal capacity, for that the servant, the master will not be held liable. It has to be something that is done in the course of employment. Okay, so the liability is restricted to what is done in the course of employment. That's very important for us. Okay, but within the course of employment, okay, it gets complicated though. There are certain things which are authorized by the employer and there are certain things which are not authorized by the employer. So for which one would the employer be liable? So all those factors have to be looked into. But one factor is that whatever is the act, whether authorized or not authorized, is something which has been done by the employee in the course of employment. Okay, and then the liability is not just for what is authorized. Okay, but anything that happens as a result of that. Okay, will also be uh, uh, you know the master would still be held liable for it. So it's not just for what is expressly authorized, but what is also incidental to it. Okay, the master would also be liable for that. So we have an important case with respect to this. I'll share the link with you, just a second. So I only have for this this Indian Kanun link, so it's going to be a long text. Okay, but the abridged facts of it is that so the defendant here, on alighting from his car, ordered the chauffeur to take the car directly to the garage. Okay, so the chauffeur was in the employment of the defendant, and he instructed the chauffeur to take the car directly to the garage. Okay. However, the chauffeur drove the car to his own residence. Okay. He had food there, and then he was taking the car back to the garage. Okay. And while doing that, he negligently drove into the plaintiff's car and then caused damage to the car. So, as you know, the defendant had said that, well, take the car directly to the garage. But the chauffeur instead went home, took meal, and while he was taking the car back to the garage, he met with the accident and causing damage to plaintiff's car. The question then arises as to whether, the defendant can be held liable for what the chauffeur has done. Chauffeur is the servant here. Okay. So the question is whether it was in the course of employment. So what do you think? Was the driver here in the course of employment?
Not really, because
Yes. Tell me. It's very important.
no, because the act that he did, the negligent act, he wasn't doing it while he was, doing anything employment related. I don't know if.
But,
So I think
but he
it
was
was
taking
in
the
the
car
course of
back to the garage. So it was in the course of employment, wasn't it?
Yes, sir.
Sir, when the car started, after the lunch and everything was done, if it was again back to its course, then it was in the course of employment, right? Like this way, otherwise, every case the driver, like sometimes drivers stop to, let's say, have a tea or something, and then they are back on their track. And then if an accident is caused, then every master can very easily escape liability by saying that, he stopped there. Hence, it's not my responsibility now anymore. He has gone out of course of employment. But whenever he comes back, he should be liable, right?
Yes. So yeah, Vikrant, both these points are to be appreciated. Okay, it's very important. Okay, and both the points are very important for I think Vikrant. The problem was that, well, the owner of the vehicle, okay, had clearly directed that, well, you go straight. Okay, you go straight, take it straight to the garage. Okay, but then the driver chose to go home, and then he was on his way back to the garage. Okay. So would that mean that because the driver was acting differently than how he was instructed, that he was not in the course of employment? Well, although you have rightly pointed out, but the second view is correct. Okay. It is that even though the driver had taken this detour, that in itself does not mean that he was not in the course of employment. He was on his way to take the car to the garage. So it was held that the defendant here would be liable. So are you with me? I mean, do I make sense? I mean, I know I had difficulty initially when I had studied this long back when I was doing my LLB. These are landmark cases, so these are going to be the same for you as it was for me. So it was decided in that particular case that, well, the liability has to be of the defendant. Okay, who's the owner of the car, we are assuming. So even though the chauffeur had taken detour. So the reason is, as rightly has been pointed out by Shivang Mishra, that yeah, so he's telling us that, well, drivers stop, they take tea. That does not mean that we should say that, well, they are outside the course of employment. That way, everyone can then escape liability. Every employer would say that, well, no, I'm not liable. So remember the third explanation, distribution of risk, responsibility, apart from qui fecit and respondeat superior, the economic argument that we discussed for why this vicarious liability exists. So you can take this as Shivang has pointed out. that might be the reason why the judges came to that particular conclusion. So, are you guys with me till now?
Yes, sir.
Okay.
Yes, sir.
Okay. So then, sorry, where was I? Yes. So yeah, it has to be in the course of employment. So by the course of employment, you know that it's not that fixed an idea. Okay, it's quite malleable. Okay, things which are not expressly authorized, sometimes even prohibited. Okay. Prohibited not expressly, but generally as a matter of guideline, if ignored by those who are employed, could nonetheless be considered as something which has been done within the course of employment. Okay, so that's a very wide definition. Okay, so when it comes to course of employment, so the act which has been done, okay, may be authorized, okay, and something that naturally arises out of it. Okay, so acts are not restricted to what has been authorized, but something that could arise as a natural consequence of that act. Okay, even in those situations, it will be considered as something that happens within the course of employment. And we have a very important case with respect to that by the name Gregory versus Piper. Okay. So look at this link that I have just shared. Okay, so facts of the case are like this. Gregory owned a pub called the Rising Sun with a stable yard in the back, which could be accessed by a back gate through Old King's Yard. Okay, Piper here owned the property surrounding the Old King's Yard and disputed G's right to pass through the yard to his stable. Now P here, okay, Piper, employed a laborer S to lay down a quantity of rubbish consisting of whatever, okay, near Gregory's stable yard in order to obstruct the way. The part of this rubbish rolled against Gregory's wall and gates. So you see, they already were in a feud. And G refused to remove it. Well, why would he do that? Okay, so I didn't do it. So why would I be responsible? G raised an objection to, okay, objection of trespass as against, G. So the issue was whether a master could be liable for the trespass which occurred as a result of instructions. So P here had instructed the laborer, didn't he? So the master gave to another person in his employment. So P the employer claimed that he could not be held liable because he had instructed S, who was the laborer, not to let the rubbish touch the wall. So P had clearly instructed S not to let the rubbish touch the wall, okay, but create an obstruction nonetheless, okay. And the fact that the rubbish resulted in a trespass of G's property was due to negligence on S's part. This was the claim made by Piper, that I didn't do it, S did it. I gave a specific instruction to S to not let the rubbish touch, the wall. But if it still happened, then what's my fault? I had clearly instructed S against that. But in this particular case, despite this instruction which was given by Piper to the laborer, Piper was held liable. So a master is liable in trespass for any act done by his servant in the course of executing his orders with ordinary care. P was therefore liable for trespass as it was probable and foreseeable result of S's act which P had instructed S to do. A trespass was necessary or natural consequence of the act ordered to be done by P. So as we discussed, okay, it's not merely the act authorized. So the act authorized is to store the trash, okay, the rubbish, okay. But there was a high likelihood that if that is done, then some rubbish would eventually go touch G's wall, Gregory's wall, even though he had instructed the laborer to not let the rubbish touch Gregory's wall, it nonetheless happened because it was a natural consequence of S's act. So P now cannot say that, well, I had instructed him against doing so, because even if you had, it's a natural consequence of that particular act done by the laborer. Hence, even Piper would be held liable. So yeah, so it's not only what has been explicitly authorized, but also the natural consequences of doing that act, for which the master will be held liable. So now this is quite clear to us that master is liable for the acts that he had authorized, okay, and also for the natural consequences of what had been authorized. But what about the master had authorized the servant to do, okay, but the servant had done the same act in an unauthorized manner, okay? So the master authorized the servant to do something, okay, in a certain authorized way. The servant did that, but in an unauthorized way, okay? So what about that? What do you think would be the case, would be the situation in those cases? Do you think
So can you give an example? Because the words are a little bit confusing. Can you give an example?
Yes, we'll take many examples. Okay. So, sorry?
Yeah, wouldn't the master be still liable because it's still in the course of the employment?
Yes, so generally we will say that, yes, even in those situations, because the act which has been done is authorized, okay, because it has been done in an unauthorized manner by the servant, in itself would not be reason to say that the master is not liable. That's the broad understanding that we have. So for example, the master instructs the servant to do something carefully, okay, so you do this task very carefully, but the servant does it not with the due care that he has been instructed with, okay, and as a result some tort happens, okay, some tort happens. So what about those situations? So that's a very important problem that might arise. So in such case the master might say that, well, I had instructed the servant to exercise due care, but the servant chose not to, so why should I be made liable? Well, in such case the servant, the master is held liable. So I have shared a link with you just now. You see by the case by the name Century Insurance versus Northern Ireland Road Transport Board, okay. So something of that sort had happened here, okay. The facts are, a transport undertaking had a contract with a petroleum company for the carriage and delivery of their petrol in lorries, agreeing to insure the lorries against any spillage or fire of the petroleum, okay. So such directions were given, okay. The lorries were insured by an insurance company against liability to third parties. While one of the lorries was delivering petrol at a gas station, the undertaking's driver lit a cigarette, okay. You know that petrol becomes gas, okay, causing an explosion and consequent damages, okay. So the issues were, the first issue was, the question arose as to whether the employer or the insurance company was liable, and secondly the question arose as to whether the employee's smoking of the cigarette was in the course of employment. So this is important for us, okay, and scope of his employment for the purpose of rendering the employers vicariously liable. So it was held, firstly, the court held that the employer is the party who has the right to control the conduct of the act at the given time. The transport company was in control of their own truck drivers to deliver the petrol, and it, not the insurance company, must be held by the employer as is expected. Now, with respect to the important question, secondly, the court held that the truck drivers act, albeit careless. So remember, something that was instructed to be done carefully but nonetheless done carelessly, okay, took place during the course of his employment as he was in the midst of delivering the petrol to the tank. So it was held in this particular case that, well, it was careless act on the part of the servant here. But then it was something done within the course of employment. So the master has to be held responsible. Further says, recently authority has overturned the requirement that the act be done for the benefit for the employer. The employee was negligent in discharging of his duties by smoking as he did, yet was nevertheless in the course of discharging his duties to his employer, and thus the employer was liable. Accordingly, the transport undertaking was held vicariously liable for the damages caused by their employee's negligence. So the simple thing, apart from all the factual details here, is that yes, the master can be held liable for the servant's carelessness, even if the master had instructed the servant not to be careless. Okay, even in that situation, the master can be held liable. So yeah, even in unauthorized way of doing that which has been authorized by the master can nonetheless be liable for servant's wrong. Well, that's understandable. Okay, fine. But what about if the servant was deliberately doing something that is wrong? Okay, the wrong which has been done has been willfully done by the servant. What about those situations? I'll share a case with you guys here. I could not get a good link about this of this one. So this is again very important. So what about those situations where the master gives clear instruction, okay, to the servant that this is what you need to do while performing the particular work, and despite those instructions, the servant willfully disobeys the instruction which has been given by the master, and as a result, okay, commits some tort, some wrong. Okay, will the master be liable in such situation? Well, if it is done by the the servant in the course of employment, even though such instruction has been given, okay, the master is nonetheless held liable. So you might be wondering, how the hell is this justifiable? The master has no way out of this responsibility. Well, in a very limited case, okay, we'll discuss that. But if the instructions are general, for example, if you have employed, if you have a fleet of buses, okay, you have employed drivers to run those buses, and you give them certain instructions, okay, that this is how you ought to do, okay, but one of your drivers nonetheless chooses not to follow those instructions, okay, and as a result, something happens, okay, what happens in such case? Will the master be then able to say that, well, I didn't ask my servant to do this in a deliberately wrongful way, so I shall not be held liable? Well, that's not the case if the instructions are general. Okay, so in this particular case, the defendant company here instructed their servants not to race the car, okay, or overtake or obstruct other omnibuses. So despite this instruction, as you see on the roads, okay, contrary to the instructions, the defendant's servant didn't follow the master's order and committed an accident as a result. Okay, so in this particular case, the defendant, despite those instructions, that is the company, was held liable, though the servant did not follow the master's instruction as a manner of doing the work. Even then, the master was held liable. So the instruction, it was general, okay, that you shall drive it like this, these are the rules that you must follow, okay, this is what you must not do, but the driver deliberately chooses to not follow those. In such situation, even then, the master will be held liable. So are you guys with me till now?
Yes, sir.
I'm way past the time, but
Yes, sir.
but I think I have to complete this topic, so I'm like taking a little more time than I'm allowed. So what about the next kind of situation, okay, known as called fraud by servants, okay? What if the servants caused fraud, okay? So what about those? You know that the master will say that, well, I have not authorized my servant uh, to defraud people. I have authorized them to do, what is required in the service, okay? But the general rule is this, okay? The master will be held liable for the same, okay, if it is done in the course of the employment, okay? So for example, a particular insurance company employs agents, so for example, to collect money from people who have purchased insurance from that company, okay? But when the said agent collects the money, instead of depositing it on behalf of the the person who has purchased the insurance, you know he misappropriates it for himself. But this agent, for example, is employed by the company. In such case, even though the employee has done something, okay, has defrauded the said person, which is something not authorized by the company, by the insurance company, but the insurance company could nonetheless be held liable, okay? Why? Because the act of defrauding was done in the course of employment. But then we have a case, very important, famous case in India, okay, by the name State Bank of India versus Shyama Devi. As you can see, I have shared the name, okay, you can easily find it. In this particular case, the respondents in this case, okay, opened savings account in the plaintiff bank, okay, that is SBI, okay, earlier it was Imperial Bank, okay, having introduced by one of their friends, okay, an employee of the bank, Kapil Deo Shukla. There was an arrangement between this fellow, okay, and respondent that the former will deposit money in the bank given by the respondent, okay? So this fellow will deposit the money, given by the respondent. So this fellow, as you would expect, he, as I was explaining to you guys earlier, okay, he deposited some money but embezzled some other amounts, okay? So when the respondent sued the bank in the court, okay, contending that they are responsible for the acts committed by one of their employees, the trial court partly agreed, but when the matter was taken on appeal to the Supreme Court, it was held that bank cannot be made liable because the act of the servant in this case has been done outside the course of employment, okay? So the said person was introduced by a friend, okay, and he was doing it not as an employee of the bank. He was doing it outside the course of employment. So the employee, when he had committed the fraud, was not acting within the scope of bank's employment, but in his private capacity as the depositor's friend, okay? So he was acting as the friend of the depositor, not acting as an employee of the bank. Because if he was acting as an employee of the bank, his role would have been quite different. So we need to look into the facts. This in itself does not tell us. But then you can make this distinction here clearly, that if the act were done by the said person, the K.D. Shukla, for example, here, if he had done it, okay, while he was in the course of the employment of the bank, and while doing that he had done so, then the bank could have been made liable. But as you know, the company cannot be made liable for every act of that person. So while he embezzled the money, he did it in his own personal capacity. Although it becomes problematic because why? Because, well, sometimes a person is employed by a particular company, and to an outside world, there's an impression that, well, this person is acting as under employment of the particular company, but that may not necessarily be the case, okay? So how do the rest of the world make that distinction? That's a problem, okay? For smarter people it's easier, okay? For others, okay, it may not be. So this case although tells us the difference, okay, but also creates a certain kind of confusions for us. But it is understandable. It is understandable in the sense that not every act of those who are employed shall be a reason for holding the master liable. So, and then what if a theft is committed by a particular servant? What about that? So we have, I'll share a case here with respect to that. So the case is by the name Morris versus C.W. Martin Sons. Okay, so in this particular case, what had happened was that Morris had her coat dry cleaned, at which time the dry cleaner stole the coat. Okay, it was the dry cleaner who stole the coat. Okay, she then sued, but the dry cleaners said that they had taken all reasonable care to look after the coat and should not be held liable. So the issue was, could the dry cleaners be held liable for the theft of an item by one of their staff? Okay, so it was one of the